The event is jointly hosted this evening by Quadrant Chambers, where I'm based, and the Institute of International Shipping and Trade Law at the University of Swansea, where my co-general editor, Professor Andrew Tettenborn, is based. It was in January 2018 that Simon Gault asked if I would be interested in taking over the editorship of Marsden and Gault together with Andrew Tettenborn. And I did not hesitate, because Marsden's one of those works which I don't just use as a practitioner, but I actually feel quite affectionate towards. I don't quite know why, but there it is. It's been around for 140 years. Its first edition, which is still in print, very well worth getting hold of, from the Law Book Exchange in America, is a taut 250-page treatise. And over the course of the subsequent 14 editions, it's grown to over 1,000 pages of text, and has become, in the very kind words of Sir Nigel Tier from the foreword of this latest edition, the source of much learning which would otherwise escape the attention of the busy practitioner. It's fair to say, though, that by the 10th edition, it had become somewhat bloated and somewhat ungainly. Luckily, at this point, Simon Gault came along. He stripped the book back virtually to its keel and rebuilt it, which is why it still bears his name. Andrew and I have done our best to continue his work in this new edition by both trimming it down and bringing it right up to date. We've shaved off nearly 200 pages and at least as many footnotes. We wanted it to be both a post-Brexit and post-Evergreen edition, which is in part why publication was delayed until the end of May. Although in this edition, Andrew and I simply divided up responsibility for the chapters between us for the main text, we have received a great deal of assistance along the way. We're particularly grateful to David Handley of Watson Farley Williams for his assistance as a master mariner with the commentary on the collision regulations in what is now chapter 7. Captain Julian Brown, who revised and modernized no less than 5 of the technical appendices, and Monica Sundklav of the Swedish Transport Agency for her section on vessel traffic services. Over the last 3 years, Stephen Clausard at Sweet and Maxwell has masterfully combined just the right mixture of pressure to keep the chapter proofs coming in, as well as patience when they rather inevitably, at least in my case, if not in Andrew's case, didn't arrive quite on time. Last by no means least, I'd like to thank Callie Lemmy from Sweet and Maxwell. Just when anyone who's written or edited a book knows what it feels like. The text is finally finished. You sent it off by email, but then the real work begins on the footnotes and the cross-references. She helped us over that last hurdle with good humor and efficiency. So thanks very much to her. I'm delighted to say that this evening we're joined by Sir Nigel Tier, who retired formally at least in October last year after 13 years as the Admiralty Judge, but who continues to sit in the Admiralty Court as well as accepting appointments as an arbitrator from 10 Fleet Street arbitrators. He will then be followed by Professor Baris Sawyer. Baris has been the director of the Institute of Shipping and Trade Law at Swansea University since October 2010. And as you know, all of you, he's published very widely, particularly in marine insurance. He is going to be the question master for this evening, and the chat function is open. So as anyone who has a burning question about particularly this new edition of Marsden is very welcome to post the questions there, and Baris will deal with fielding those and putting them to the relevant person. After that's finished, we'll be holding a virtual networking session using Zoom breakout rooms. You will be randomly allocated, you'll be pleased to hear, to a breakout room. None of this is compulsory, but if you are interested in participating, if you use the, I'm told, if you use the breakout rooms menu at the bottom of the screen, you'll be able to see a list of the rooms and who is in each of them. And if you particularly want to avoid someone, you click on the link very quickly to move from room to room. So in that extent, it's actually easier than real networking in a real room. Well, then apparently randomly the dice is rolled again, and you keep moving into a different room until everyone has gone home. With that, Sir Nigel, over to you.
Thank you very much, John. The number of collision actions which reach trial is very small. And as we have been recently reminded, a collision action reaches the Supreme Court only once in 50 years. It is therefore remarkable that we are assembled by Zoom to celebrate the publication of another edition of Marsden and Gault on collisions at sea. But as the arrival of a new edition suggests, much has been happening in the usually placid waters of collision actions. The advent of voyage data recorders has had several consequences. On the one hand, they have led to many collision actions settling. There is no need for a trial to discover what happened when a black box can tell you all you need to know. But on the other hand, voyage data recorders have spawned new rules, both in court and in collision arbitration, for the exchange and interpretation of electronic track data. Voyage data recorders are also giving rise to their own problems. The cost and time required to interrogate a black box, particularly the audio record, is considerable. Case management must factor that in. The circumstance that the facts of a vessel's navigation can be identified with precision without a trial has given rise recently to questions concerning the format and detail of a collision statement of case. The manner in which a vessel's navigation is to be presented to the court is also the subject of debate. Is a conventional plot and accompanying schedule sufficient, or should a video reconstruction be permitted? That is another subject for case management. As I remarked in a recent case, my predecessors would have had difficulty in recognizing the shape of a modern collision action. These are questions of procedure which remain to be fully explored and developed. But the recent judgment of the Supreme Court has, for the first time, explained how potential conflicts between particular collision regulations are to be resolved. That is a question of substantive law and may lead to further disputes about the application of the regulations in the future. In addition, Sir Henry Brandon's article on apportionment of liability has belatedly been placed centre stage, and that also may lead to more sophisticated debates on apportionment than were common in the past. In that context, the arrival of a new edition of Marsden and Gault on collisions at sea is timely. This 15th edition comes just 5 years after the 14th edition in 2016. That is comparable with the rate at which 9 editions appeared between 1880 and 1934, a period which saw, by comparison with the present time, much collision litigation. The 15th edition has been edited and, as they explain in the preface, partly rearranged and rewritten by 2 distinguished editors. Professor Andrew Tettenborn is a prolific author and an acute observer of recent cases. Given the contribution which the Institute of International Shipping and Trade Law at Swansea University has made to the better understanding of maritime law, it is fitting that Marsden and Gault on collisions at sea should be so closely associated with that institute. John Kimball, Queen's Counsel, practices in maritime law, sits on the Admiralty Court Users Committee, and is chairman of the Admiralty Bar Group. He is therefore very well placed to comment on the recent developments in the management and determination of collision cases. Marsden, and latterly Marsden and Gault, has been close at hand throughout my professional life. It is impossible to imagine a collision action which does not require the advocates to refer to it, and in an appropriate case, to research the cases in the many valuable footnotes for helpful comments by the judges of the past. I have no doubt that this edition will be on the shelves of Admiralty advocates and of the Admiralty judges of the future for years to come, and I congratulate the editors on its publication.
Thank you, Sir Nigel. It is always a challenging task trying to follow Sir Nigel, who occupies a legendary status in the world of Admiralty, but one can only try. First of all, on behalf of the Institute of International Shipping and Trade Law at Swansea, I would like to thank Quadrant Chambers for jointly organizing this event, which gives us an opportunity to celebrate the success of two eminent lawyers and also great networking opportunities, as highlighted by John. Then I would like to thank two authors, John and Andrew, for not only inviting me to say a few words, but also providing a great contribution to law and practice in this field by authoring 15 additional Marsden and Gault on collisions at sea. Yes, as Sir Nigel mentioned, it has been 140 years since the first edition of this book saw the light of day. Lots changed since then. We use better navigational aids, as Sir Nigel indicated, sometimes confuse ourselves, sometimes confuse the litigants. We have Google since then. We joined the EU, we left the EU. We have gone through several global pandemics, and we are going through another one as we speak. We have had 2 world wars. We have a climate change issue. The list goes on. But certain things remain unchanged. Marsden on collisions at sea was a leading text for lawyers and practitioners then, and it is now. For this edition, I noticed some restructuring has taken place, and I will ask about that to the authors in a minute. But I must say that I have a copy here. I have found the new edition to be more accessible, probably as a result of the changes. Another feature of the edition, the new edition, is that it is very contemporary indeed. The authors managed to include commentary with regard to the Supreme Court judgment in Evergreen Marine versus Nautical Challenge Limited, which I believe was handed down on 19th of February 2021. Well, that is impressive, and I suppose credit here goes both to the authors and publishers. But enough of me. I would like actually to find out more from the authors, from John and Andrew, about the new edition. And in that context, I would like to put the first question to Andrew. Andrew, in a nutshell, could you summarize us what will lawyers notice about this new edition?
I think actually what lawyers will notice is what a lot of people have already referred to. One thing that struck me when I took this over was that the arrangement of the book, I'm not sure if it dated back to the 1880s, but it certainly dated back to the 1920s and had all sorts of divisions, such as, for example, liability in contract, liability in tort. If someone was killed at sea, you had to look at liability under statute. Why? Because if somebody was killed, it came under the Fatal Accidents Act, and that was a statute. And so on and so on. It had just sort of grown rather like Topsy. And okay, Admiralty lawyers knew their way about it, but nobody would have written it in that order. And it was a very good opportunity, with just 2 of us editing it, to put it into the sort of order that you find in a contemporary book. And also, I think we took the opportunity to increase and update the coverage of a number of topics which are actually very important these days. Jurisdiction. Anybody who isn't at the bar, it tends to be surprised at the fact that very often the question isn't, are they liable, but can we sue the blighters here? Or if somebody's sued them elsewhere, can we enforce the judgment? Or which system of law might apply? And it's contemporary issues like that which have very much informed what we've done. What we've also done is taken out a lot of the old 1920s to 1880s cases, which dated very much to the era of Captain Haddock of Tintin fame, when shipping was much more informal and safety was much less important. And I think with every case, we've looked at a reference and said, is that actually likely to be of interest to a lawyer in 2021? And if it isn't, I'm afraid we've been quite brutal and chucked it out. Especially, of course, if you could only find it in Aspinall's maritime law cases, which isn't the easiest set of law reports to find.
Thank you, Andrew. John, I mean, since we're talking about restructuring, I have noticed that you divided the old navigation chapter into two. Would you be able to elaborate the logic thinking behind that?
Yes, I mean, there were two reasons. Certainly, as a practitioner using Marsden, I tended to think of it as principally as a commentary on the collision regulations. And I wanted to be able to dive in and find the relevant rules that I was interested in. And I did find it slightly irritating that every time I turned to the then relevant chapter, chapter 5, which wasn't even entitled commentary, it was just navigation, you had to go through about 100 paragraphs of historical material before you got up to even 1972. So the thinking was to try and make it but on the other hand, we didn't want to, for very good reasons, dump all the historical material, because it's very important for understanding the old cases. So the main change, one of the main changes, is to divide the historical overview section, which is now 81 paragraphs long, and to put it in its own chapter. That's where you go to if you want to understand some of the old cases. If you want to know now what the position is under a particular rule, you can dive straight into chapter 7, and there each of the relevant rules is highlighted in bold. So we try to make it more accessible. So that was the first change. The second change was we thought it is essential that a master mariner review the entire chapter. So chapter 7 was reviewed word for word by David Handley of Watson Farley Williams to make sure it made sense to a mariner. And many of the sentences were, I'm afraid, so long that they made sense perhaps in 1920 or 1880, but they needed to be cut down. So we hope we've kept everything that mattered of substance, but made it more accessible, and in particular to the master mariner. Thank you.
Andrew, you did mention a bit about updating the jurisdiction issues, but a bit more precise, what are the most important developments covered in this edition compared to the last one?
Well, I think when it comes to jurisdiction, obviously it's Brexit, because Brexit has completely rewritten the English rules as to jurisdiction. We thought it wasn't going to, but it now seems pretty clear that Britain won't be going into Lugano anytime soon. So obviously we're back to the old rules on jurisdiction. That in some ways actually makes it easier, because if you can arrest, or these days threaten to arrest, you now actually get jurisdiction almost automatically. This was something where the European lawyers had actually made life enormously difficult, because of course a European lawyer doesn't really know what an action in rem is. You know, cross the channel and nobody really understands the difference between an action in rem and an action in personam. So to some extent, actually, it's a matter of simplification. But obviously that has to be discussed in considerable detail. What we've also done, given that some of these cases can be long tail, just in case anyone is frightened that they will lose the European sections, we do actually have specific reference to the old European rules. Relevant to long tail cases, relevant also, of course, to anyone, say, in Ireland or some other European jurisdiction who might be interested in buying the book.
Andrew, is it me, and I can't claim that I have read it from cover to cover, but I also seen something on VDRs, which I don't believe was there before. Is that right?
Oh, absolutely. We've been bringing the book absolutely up to date as far as we can in terms of technology. Because if you looked at the editions actually up to and including the 14th, for which I take a fair amount of the blame, it was still very much in the mold of the collision action being heard in front of the Admiralty judge underneath his anchor, with grizzled mariners giving evidence on either side, with the old preliminary act in Admiralty, which is best described as the exercise of saying as little as possible in one side of A4. So as to give as little as possible away to the other side. These days, that's all gone out of the window. As Sir Nigel was mentioning, half the time, actually, you have Admiralty actions almost without oral evidence. Basically, it's just a couple of chaps, or increasingly, actually, a couple of people looking at computer screens and working out what happened. So we've been very aware of the necessity to incorporate modern technology. I think we may even occasionally have mentioned what happens when you have a ship controlled by a computer. But we've very much tried to bring that into the book on the basis that we want the book to read like a book which is useful to someone in 2021.
Thank you.
Yeah, if I could just follow that up, Barris, and say that there was actually a VDR appendix in the old edition, in Appendix 18, but we were very lucky to have Dr. Neil Baines from Avenka, who agreed to rewrite that appendix altogether and bring it absolutely up to date. And similarly with Captain Brown on navigational charts and data. And just to give you another example, we had a former appendix which was called Radio Navigation Systems, which tells you how old that was. That's now been replaced by positioning, navigation, and timing. So it was very important to Andrew and I that although the lawyers don't always use the appendices, that they are fully up to date, and we have been very, very pleased with the assistance that we've received from the technical experts, in particular Neil Baines, who's with us tonight.
Thank you. There are some questions coming in, actually. I don't know whether you could see, there's a very lengthy question from Darius, a very good question, actually, concerning your views. So I leave that one for you to read for a minute. But there is also a very, very interesting question from Thomas Macy there, QC. The English Admiralty Court is currently consulting on possible changes to the procedure governing collision statements of case for reasons touched upon by Sir Nigel. What view do editors take on that? I hope this is not a kind of googly to you.
I think this is probably something for John, isn't it? Who's very much more the procedural person. Basically, I think what they're getting at is whether we should get rid of the collision statement of case as a special kind of pleading.
Yes, I mean, Thomas is absolutely right. There's at the moment, as a consultation, we're trying to gather, the Admiralty Court Users Committee is trying to gather as many different views as possible to see whether, in particular, whether there ought to be a different approach to cases where there's electronic track data. I mean, that is already built into the rules. Under Sir Nigel, changes were made to CPR Part 61 and the practice direction to ensure that there's a very early exchange of that track data where it exists. But we're also very conscious that there are cases where it doesn't exist, and should there potentially be a difference of approach in the collision statement of case. And I think another thing that's, without wanting to give away the early responses, one theme that has come up quite often is whether there ought to be another round of pleadings, so that at the moment, as everyone knows, there's a blind exchange of initial pleadings and no response. And certainly so far, there's been a movement towards, a significant number of people have said, well, in order to properly define the issues for trial, it would be helpful for there to be responsive pleadings in some form. And I would align myself with that.
Thank you. I think it's very interesting. I had a few more questions myself, but since very good questions are coming, maybe we can carry on. With Darius's question, I think you had a chance to look at, I believe. He refers to paragraph 41 of the Evergreen Marine Nautical Challenge case from the Supreme Court, and I'm not going to read that one. But his question, I'm very happy to repeat to you when you are actually thinking. Whilst rightly concerned with situations facing amateurs in small boats, did the court, in your view, also adequately understand the practical difficulties daily faced by those in charge of very large, very drafted and unmaneuverable ships in similar situations? And has the Supreme Court therefore also achieved its aim of interpreting the rules in a practical manner when applied to such large vessels in Group 3 scenario? This looks a bit like a very specific question, but if you want to have a general answer, either of you, we would very much welcome it. Clearly, audience sees you as authorities in the field, quite rightly.
I think there's always been a difficulty, actually, when you've got a fight between a VLCC and a weekend sailor, and it's got worse. The thing is, when the collision regulations were being developed, there was less of a difference. The absolutely enormous vessels that we have today didn't exist. And there was at least a little bit more commonality between the average ship you tended to come across and the small boat, which might be sailing in and out of whichever port it was. The trouble is, whatever your view as a lawyer these days, the only advice you can give to the owner of a small boat faced with a VLCC is keep well clear. It's all very well saying, well, you know, the VLCC has to take care and so on, but frankly, there's not a great deal the VLCC can do. So I think that is very much the practicality. I don't know if John has a different answer on that.
No, I would agree with that, Andrew, and I am a fan of the decision, I have to say, and I think it's set a good course for the proper interpretation of the collision regulations. I think they have. It's impossible to have on the central rules, such as the crossing rule, different rules applying to different sizes of a vessel. And insofar as it's possible to distinguish between them, the rules do that. So they already take account of different size vessels. But in terms of the overall approach to interpretation, I have to say I thought the Supreme Court's decision was bang on.
Thank you.
Very well, you know, other people may have other different views, and anyone can speak. It's not as a webinar where everyone is forced into silence. If anyone's got a different view, please chip in.
Well, after that challenging question, I think as due to your quiz master, I believe that's a position John appointed me, probably to ask you an easier question, before we come to the end. And actually, whoever wants to take this, what was the most enjoyable and the least enjoyable aspects of working on the new edition? John?
What a good question. Well, I can tell you the least enjoyable, very easy, the footnotes. Oh, that was awful. Page after, filling in a table. I'm sure there ought to be, if a computer can steer a vessel on the open seas, why can't a computer do the cross-referencing? It was dreadful. So really the only reason that got done in the time was because of COVID. I couldn't leave my flat. I was in quarantine and just sat there for 4 days doing the footnotes. So that was terrible. Most enjoyable bit was actually, surprisingly for me, was dealing with the appendices and dealing with people like Neil Baines and Captain Brown on the technical updates and reading what they had to say. That was fascinating.
I must say that I'm surprised by that answer, but you know, each to their own.
Yeah, I actually took, I suppose, probably a rather professorial pleasure in this, because previously Marsden had been edited. I think the last edition had 6 editors, if memory serves me right, but I may have got it wrong by 1. Actually, it was a great pleasure to have control over a very large part of the book, because that for the first time gave you the opportunity of removing repetition, making sure the book was self-consistent, making sure the book actually read properly as a whole. Whereas, of course, previously that job had been almost impossible, because it would have involved liaison with other people saying, have you checked this particular part of your chapter? Please have a look at it. Have a look at this particular part of my chapter. Do you agree that you should deal with it or that I should deal with it? Or, you know, can we please agree at least on one view, because we disagree at the moment? Being rid of that was actually an enormous relief, and gave one the pleasure of being able to construct a slightly more artistic whole. Sorry, that sounds enormously pompous, but I think it's quite important.
Well, no, nobody had the impression that you are a control freak, Andres, so no, perfectly acceptable. Okay, at the end, could I actually suggest, this is turning out to be a very, very cheap occasion for Quadrant Chambers, because we are bringing our own drinks. Could I suggest that we raise a glass to all the previous editors, first of all, in particular on my mind, just on the opposite side of my screen, Simon Gault, who's done a fantastic job with the previous editions. Could we raise a glass to the previous editors, a glass to the success of the 15th edition, and I genuinely hope that the succeeding editions will be as good as this one.